Welcome back to Tort Talk. This is John Robinson here. Mark Ryu is on vacation this week, but Joe Fantini is still joining us. We've got some big updates for you on social media addiction, on Bair Hugger, on NEC, on barred PowerPort. We've got a bunch of updates. We're going to start right now with social media addiction. Joe, thank you for joining us.
Thanks for having me, John. Excited to talk about some trials, which we always like to hear about in the mass tort world.
Here's probably the most important question you can ask your marketing agency. Who are they really optimizing for? Because if the answer is internal margins or shareholder expectations, that changes how strategy gets built. RR Digital stays independent so we can optimize around one thing, law firm growth. That means cases, clients, and revenue. If you're rethinking your marketing partner, visit rrdigitalmedia.com and let's start the conversation.
This trial has been going on for about a month. The trial of the year finally heads to the jury. We've received 2 questions from the jury to Judge Kuhl. The first regarding the definition of negligence, with the second question focusing on how to determine if the plaintiff's design was a substantial factor in plaintiff's injuries. What do these questions infer about what might happen in this case?
I think these are posed 2 positive questions from the plaintiff's perspective. It doesn't seem like the jury would come back with those types of questions if they just outright didn't believe that there was any connection or association between the plaintiff's usage of the social media platforms and her injuries. So what it showed to us is that these juries were very engaged, they were taking notes, and they're really honing in on what are the key factors in this case. It's going to be whether or not the defendants were negligent, so the duty that they had to the plaintiff, if there was a breach of that duty, and if that causation caused the plaintiff specific injuries. And then the second question goes to more whether it was a substantial harm, a substantial factor in bringing about the injury. So throughout the case, we heard from the defendants that it was the plaintiff's own fault. It was her mother who wasn't attending to her. It was her home circumstances that caused these injuries. It wasn't the platform. So these questions lead me to believe that initially the jury's on the side of the plaintiffs, but we'll have to see when this verdict comes down. I think we'll have it before the end of this week.
Very interesting trial. Always great to hear about Mark Lanier's theatrics in the courtroom during opening and closing. Hopefully we get a good win for the plaintiffs here, and then we move on with some positivity. Up next, we have Bair Hugger. So we're wrapping up the state trial in Texas. What are some of the key takeaways from the trial that inform what might happen in the rest of the MDL?
Yeah, so this is the 4th case to go to trial in the 12-year existence of this litigation. You mentioned it's in state court, so it's outside of the MDL, but basically we had another 3-week trial, very heavy focused on the science. So I think from the defense perspective, they were really leaning in and relying on the experts about whether or not the use of Bair Hugger could lead to the development of these infections. I think the defendants relied maybe a little too heavily on some of their experts and really diminished what the plaintiff went through, and that this was an actual plaintiff who's sitting there right in the courtroom and suffered some injuries. So the plaintiffs were able to score some victories. We got some good evidence in, and now it's coming down to what we'll call the battle of the experts. And so we'll see what side the jury ends up favoring. But what's interesting about this case is it's not one of those tier 1 injury cases. So usually when a case goes to trial in a Bellwether case, it's going to be a case selected by the plaintiffs or the defendants, and usually one of their best cases. This case is definitely a serious injury case, but it's what we'll consider a tier 2. So the tier 1 cases in this litigation involve amputation. So this case involved multiple surgeries. So if plaintiffs can get a victory in this case, it's going to really help the momentum and give us a roadmap from the next trials that get tried in the Bair Hugger litigation. So another trial we'll be watching this week. We should have a verdict before the end of the week in Bair Hugger. 2 important verdicts with social media and Bair Hugger coming down in no time at all.
And another trial that is underway, NEC, necrotizing enterocolitis, which is based on dairy in baby formula. And the trial just got underway in Cook County Circuit Court in Chicago, involves 4 children born between 2012 and 2019 who developed NEC. Why are these trials so important to the litigation overall?
Yeah, these trials are huge because we've had some setbacks in the MDL. So there's parallel state court proceedings going on in Illinois, in Missouri, some in Philadelphia. But in the MDL overall, we have about 800 cases pending. We've been trying to get to a Bellwether trial in the MDL, but each one of those cases coming up on summary judgment end up getting kicked out by the judge. So the next MDL trial is supposed to start this summer. Who knows if we'll be able to get there? We've had 2 pretty big verdicts in state court in Missouri and then Chicago, but hopefully we can get a 3rd verdict, and this is going to really continue to put pressure on the defendants. I think if we get this verdict, pretty much all of the attention is going to shift to the state court proceedings and getting outside of the MDL, but we really need to get momentum back on our side because the defendants definitely had some wins so far in the end of 2025 and throughout 26. It's been all in their favor.
This is an interesting one, right? Because you've got the product and you've got the manufacturer who is saying in some instances that it is the hospital, right, that potentially was the one that was negligent and not the product itself. It's really interesting, like how this one has been developing and the results that we've seen so far.
That's what we see a lot of times in these cases, right? A product liability case. The defendants blame everybody. They blame the plaintiff or they blame the surgeon who implants the device. Here they're saying that the care wasn't proper by the hospital, like you mentioned, so they're pointing the finger there. But hopefully we can get a nice verdict with 4 plaintiffs. It could be a sizable one. It's going to be at least a month-long trial. Could be sometime in May even until we get a verdict. So we'll keep everybody updated as this moves forward.
And yet another trial, we've got Bair PowerPort set to kick off trial in April. What can you tell us about some of the recent developments in the Bair PowerPort MDL?
So this trial, we're going to have the first Bellwether trial in about a month from now. In the MDL, we have a little under 3,000 cases pending, and we just heard from the judge on some very important Daubert rulings. We didn't get all of our experts in on every opinion they had, but we have enough to be able to survive the case, go forward, get to the jury. Interesting enough, there was a rather sad development that the second Bellwether trial, the plaintiff in that case, who I believe was to start in July, ended up passing away from cancer. So it looks like that case is now out of the pool. It looks like we're going to have to wait maybe until the later part of the summer, August, to have the second case. So we'll have this first Bellwether trial kick off. A lot of people are really watching what the developments are going to be. Is it going to be similar to what we had in Paragard IUD, where it's a tough case? These cases can be hard. Or are we going to be able to come out with a victory, and then there's going to be some momentum with the pressure of an additional Bellwether trial coming up right around the corner? So we'll have to see how the jury takes this case and the evidence from both sides. Hopefully it'll help us build a stronger case to get these cases wrapped up as well.
Yeah, this is a tort that I like a lot. I've been following it since the beginning. I think the science is there. It'll be interesting to see what happens with this first trial here coming up in April. Speaking of April, we are less than a month away from MTMP in Vegas and less than 2 months away from Mass Torts Puerto Rico. So should be a lot of news coming out about developments in emerging torts and a lot of discussions amongst attorneys who are leading some of these other MDLs that are already established. I will be there. Mark will be there. Joe, we'll see you at MTMP.
Yeah, I'll be there, of course.
And then we'll have Puerto Rico right after that. So we look forward to seeing you there. If you're watching, make sure you catch up with us. Joe, Mark, and I are always walking around looking to talk to everybody who listens to Tort Talk. With that, we will see you next week. Mark will return. Joe, thank you as always for joining us for the best 10 minutes in mass torts each week.